conscience is so tied up with what it is to be a human being, and yet conscience today is really not understood. It's little more than what I feel, right, or subjective opinion or something. That's not what's protected in this.
Okay, great. Well, it was interesting right before we started recording. Both of you brought up a Canadian philosopher, and I think, Your Grace, you were saying he's the one that said that the medium is the message. What's his name?
Marshall McLuhan. I forget how we got on to that. We talked about this before we started, but Kevin was certainly...
It's just interesting to hear about a Canadian philosopher. I don't remember, haven't encountered many.
There's lots of good things come out of Canada, Jenny. Lots of good things.
Oh, that wasn't my implication.
but it came from Montreal, so I don't know whether that really counts.
There you go. You go. That's a hot take right off the bat. We couldn't have asked for anything better.
You can tell we're interviewing a lawyer today. He just starts off with these little zingers. Right?
Well, Montreal in the late 60s, early 70s, the time of the Cultural Revolution there.
Yeah,
sure.
The time of Le Cité Libre and Pierre Trudeau's move to play with federalism a little bit there, and the FLQ, a very interesting time.
It was a time of a lot of tension.
Oh, yeah.
Was he, what's his name again?
Marshall McLuhan.
Has he been someone that's informed your thought as a judge, a lawyer at all, or just more of a point of interest?
Oh, he's a philosopher of the media.
Okay.
The media has become so pervasive in our world that it's nice to have a philosopher of the media who can help you figure out, why we do things, when we do things, what the result is, why we should be thinking about it. Very, very interesting.
Yeah.
It'd be interesting to have takes on that today with the way the social media has evolved, right?
Absolutely.
That wasn't even contemplated in his day. And what would he have? The medium is the message. Well, the medium right now is babble, it's confusion, and
it's
so
always
messages
short form.
Messages are not getting out.
Yeah, no kidding.
The problem, of course, is the distinction between informed opinion and uninformed opinion. Informed opinion is always helpful. Yep. It helps you think about problems, work through issues. Uninformed opinion is just chaos.
Great point.
Terrible chaos.
I like that. That's a good point. It's also, It's also that idea of informed versus uninformed idea. Perhaps it's a bit of a antidote to the idea of disinformation, which I think that term gets so confused. What does that even mean? It's often levied as an accusation against people, but I hadn't heard that particular phrasing. That's interesting.
Yeah, it's a more nuanced phrase than false news or the kinds of things you hear about, because it depends on who you're listening to, what their credentials are, what research they've done, whether what they've been saying has been properly vetted by peer analysis. How much can you weigh what you're hearing? It's a matter of weight. Yeah. Very little weight, no weight, a lot of weight. And there's a spectrum of the weight that you put on these things. And the more informed, the better credentialed, the better researched, the better peer-reviewed, the more weight. Yep. And we should only be listening to things with significant weight, not things with zero weight.
Yep.
And I'd love to find out a way that we can, in some kind of future episode, develop that a little bit further, because just to take your terms, and I'm really grateful for them, we're giving a lot of weight today to what, in fact, is weightless.
Yes.
Right? And that's just causing a whole lot of confusion. So.
No kidding. Yeah, we've got our priorities and our ability to assess whether something is weighty or not is really skewed right now.
And we all are communicating in bubbles. And that is, we are only listening to the people that think like we think. And the big challenge today is to go out of your way to listen to the people who think differently than you think, and figure out why they think differently than you think, and to figure out whether there's any weight to that. Yep. So we have to get out of our bubbles. We have to look far, far, far more broadly than we currently do.
Yep.
Well said.
Yep. And which is a really good point, because we're so grateful to have you. You're a lawyer and a judge with the Alberta Court of Appeals in our province here, and your voice on the matter, particularly today on freedom of conscience, religious freedom, is certainly informed. So we're very grateful to be be able to hear your insight on this topic.
She's making assumptions that I'm not sure she should be making.
You are
At
the
all.
only.
At all.
You are the man.
They're pretty safe. So,
Well, you're very humble, which is also a good point of communication. We're talking about freedom of conscience, freedom of religion, and how would you define the distinction between those two? Because I know that in the Charter of Rights and Freedoms, they are, as I understand it, put together.
Correct.
So is there a big distinction between them? Because clearly they are tethered.
Like everything in law, the answer is yes and no.
Oh, yay. Yay.
So,
I love that. My journalistic heart just breaks.
freedom of conscience and freedom of religion are together in a single phrase in Section 2A of the Charter of Rights and Freedoms.
Yes.
And they are the very, very first fundamental freedom outlined in the Charter. And that gives them a priority. Now, why do we have two phrases rather than one?
Yeah.
And the answer is quite simple. The basis for freedom of religion has got to be theological. The basis for freedom of conscience is philosophical.
Okay.
And so to put them both together is to give you a fundamental freedom to express your theology and your philosophy. And some people will weight philosophy heavily, some people the philosophy heavily. And as we know from our religious education at places like Newman, both are critically important. And you have to know how to address these matters from a theological and from a philosophical point of view. And the beauty of the section is that it puts them together and it invites you to look at the issues theologically and philosophically.
So if I might ask, when you talk about the distinction about between theology and philosophy, when the leaders who drafted the Charter of Rights and Freedoms, were they thinking with that amount of clarity about, well, we want to give people a philosophical and a theological perspective, or is that interpretation in the aftermath?
The answer is yes and no.
Oh, yay. I see a theme here.
The question is, how deeply did they think about the problem?
Okay.
The talks to bring in a Charter of Rights and Freedoms lasted for 2 years, from 1970 to 1972.
Yeah.
And people came and talked for 2 weeks, and they went home for a month. And they came and talked for 2 weeks, and they went home for a month. Sort of like Vatican II happened, over a period of time. And so the theory evolved. And I happen to know the story here. And that is originally Pierre Trudeau had only put in freedom of religion. And then Jean Chrétien came in very late in the game and said to Trudeau, I want you to add freedom of conscience. And Trudeau said, why do we need to do that? And he said, because not everybody is going to claim a religious base for the beliefs that they have. But everybody, or most people at least, will claim a at least philosophical or conscious-based reason. And we need to give everybody in the country the right to claim a fundamental freedom. And if they can't bring it through the religion aspect, they can surely bring it through freedom of conscience. And so it was Jean Chrétien persuading Pierre Trudeau to change the original draft very late in the process.
Do you gentlemen see that as wisdom? Like Jean Chrétien coming in and saying, well, this shouldn't just be religious, because again, there's going to be, as we know in Canadian communities, there's lots of people who wouldn't claim the term religious, right? They would be more generally spiritual, or maybe they would just operate on a world philosophy in general. So do you see that, Your Grace, do you see that as a wisdom of inviting that?
Oh, for sure. And I think it's a wisdom that has proven itself in subsequent years, because back in the 60s, maybe the late 60s, the percentage of Canadians who would have identified themselves as having no religion is rather small. Now it's growing, right? So we have maybe 30%, pushing 40% of Canadians in recent census that are saying they identify as the none, the N-O-N-E, increasingly higher among young people, which really draws the attention more and more to the importance of conscience. And I do think increasingly that's one of the key issues that we've got to grapple with today in our society, because conscience is so tied up with what it is to be a human being, and yet conscience today is really not understood. Right? It's
Yeah.
it's little more than what I feel, right, or subjective opinion or something. That's not what's protected in this. So I didn't know that story, but I'm glad to hear that interjection was made.
Which is a good point, because when it comes to conscience, you're saying, again, people's consciences are formed on such a broad spectrum, if they're formed at all, right? And they're going to be formed by different things. So to your point, how is the idea of freedom of conscience essentially just saying freedom of whatever you believe to be right in any context, no matter what you feel? It becomes quite vague.
Yeah. If one is going to the court to argue either a freedom of religion case or a freedom of conscience case, they have to meet two criteria.
Okay.
The first is they have to prove that they conscientiously believe it. It's a heartfelt belief. It's one of the things that informs their life, that informs their decision-making, that informs their lifestyle, that informs the choices that they make. That's criteria number one.
Do they prove that by saying, oh, look, I have a history of making decisions based on this?
Yeah, that's one of the ways you would prove that.
Okay.
But you've got to prove to the court that this is a heartfelt, truly personal belief system that you have, that you live your life by.
Okay.
That's number one. Number two, you have to show that the law that you're concerned about has prejudiced that in some way, so that it has had a negative effect upon it. And therefore, you want the court to fix whatever it was that you said was a negative effect. So you've got to play with both of those variables at all times.
Are you finding that this issue is coming before the courts more and more? Where I'm seeing it play out are on the life issues, right? And so we have medical practitioners that absolutely refuse, for example, to give euthanasia to a patient, right? And often will feel pressured, whether it's by a professional college or law or whatever, even if they're not pressured actually to do it, to refer, right? And in this way be complicit. And they see that, and I think rightly, as a violation of their conscience, the decision that they're making in conscience. So it just makes me wonder how frequent these kind of things are these days coming before the courts. Conscience is really coming to the fore in many ways.
Yeah, I've got to tell you that we do not see many of these challenges. We don't see many constitutional challenges in general, and challenges on the fundamental freedoms, not that often. But when they come, they're critically important.
Sure.
And we have to really think about them and decide what we're going to do. Quite often, there's a separation between Sections 2 to 15 of the Charter, which are the individual rights, including these fundamental rights, and Section 1 of the Charter, which is the collective right piece. And it's called the justification section, and that is an infringement of that right allowable, permissible, in a fair, just, and reasonable society based upon the collective good for the greatest number of people. And I think that some of the matters that are being addressed are shown to be breaches of individual rights. Mm-hmm. And then the real challenge then comes in balancing the individual right against collective rights in Section 1 of the Charter, and whether in a free and democratic society that individual right can and should be overridden. And that is where these kinds of questions are going to, I think, be determined.
Yeah.
And
I would think too, but just the flip side of that too is if the overriding of an individual right actually would act in itself against the good of the whole, right? So there's so many different dimensions to this. Now if you don't mind, I don't know if you're going to go in this direction, Jenny, but Kevin, you've taught me many times a fundamental difference between the way the Canadian Charter works and with respect to rights as vis-a-vis the American. And I think sometimes the American understanding of rights within the law spills over into the way Canadians think about it, but our fundamental approach to this is actually rather different.
Absolutely.
So can you say a little bit about that?
Absolutely opposed.
Okay.
In fact, the problem, of course, is that we are the mouse sleeping next to the elephant, to use the old phrase, and therefore everything American tends to influence us.
Even the fact that we watch American television all the time.
All the time.
We think lawyers are purely American.
Yeah.
Truly.
I never watch, by the way, any shows on TV that have lawyers or judges in them. I never
don't?
look at any movies because they are all complete garbage.
Oh,
Complete. Not
And
only,
yet you haven't watched them.
Oh, yeah, that's true. my prejudgment.
Yes, okay.
My prejudgment is that they're all
Prejudgment, yeah.
complete garbage.
Yeah.
But it's an important distinction.
Yeah.
So when you think about the animating words of the American Declaration of Independence, you think about life, liberty, and the pursuit of happiness.
right.
Okay? Those are fundamentally individual rights. I have a right to life. I have a right to liberty. I have a right to be happy. Very, very individual rights. In Canada, those fundamental principles of the Constitution Act of 1867 come out of Section 91, and they are peace, order, and good government,
Which is derived from English law.
which is derived from English law, and
Yeah.
they're all collective in nature.
Interesting.
You cannot have an individual peace. It has to be a collective peace. Order is a collective concept. Good government is the democratic expression of collectivity. And so we start off from exactly the opposite proposition than the Americans do in terms of emphasis on the collective good, the greatest good for the greatest number of people, if I can be a bit of a John Lockean here. And the Americans who start off with individual rights. I've got a right to bear arms. I've got a right to individual liberties that are different than what we perceive to be the right balance here. And we put a fine point on that when we did the Charter of Rights and Freedoms, because the Americans would have an equivalent of what I've called our sections 2 to 15 individual rights. They do not have a section 1, which is the balancing section that says that collective rights have to be taken into consideration if there's a breach of individual rights. They don't have that collective justification provision.
So this idea of Canadian collectivism versus American individualism, how does that impact Canadians' relationship with religion and the freedom to religion? Do you see there being a big impact because our philosophy is so different?
I think there is a massive impact.
Okay.
And I think the impact is this. So when the Americans talk about the separation of state and church, okay, they talk about there should never be any respect for religion from a political point of view. They should never
Respect?
Well, respect is maybe too strong a word, but there should be a strict separation. Canada is exactly the opposite position, and that is Canadians want pluralism in their church-state relationship. They don't want the state to say there must be one religion, or one religion is better than the other religion, or you must follow the precepts of a religion. What they say is religion is good. Religion should be available to everybody who wants a religious life experience.
Canadians say that.
Canadians. And we must respect all religions. We must promote all religions. We must have a pluralistic view of religion in society, which is exactly the opposite of an American view. You know, you can't say prayers in schools. And, there's got to be a complete, separation from the church and anything that's run by government. Here, it's very much encouraged. And in fact, in Alberta and Saskatchewan, by virtue of this is getting way too geeky, of the Alberta and Saskatchewan Act of 1905, there is a constitutional right for public schools to say the Our Father at the beginning every day and to have half an hour of religion at the end of every day. That's in the public schools.
So, but why Christian? Because if there's a presupposition in Canadian government community that we want pluralism, why the Our Father? It's Christian.
Well, that's true. That is an historic anomaly because in 1905, there was really Catholics and Protestants.
Mm-hmm.
Right.
Right. There was a very small Jewish population, but there was fundamentally almost nobody from representing Islam or representing Confucianism or representing Buddhism in this country.
Which is such a drastic difference from now.
Oh, massive difference.
Wow,
Massive
and
difference.
we're only 150 plus years old.
That's exactly right.
Wow, yeah, look at me.
So
I'm doing math.
and so some of the deals that were made to bring Canada together in 1867 had to respect the Catholicism of Quebec and the Protestantism of Ontario. And so those were the compromises that were made, particularly in, for example, Section 93 of the Constitution Act that protects the right to Catholic education in provinces to become provinces at that point in time. That had a Catholic education basis.
Have you found when you're in dialogue with American bishops, or really dealing even with members of state in an American context over your years as bishop, have you seen that to be a difference in philosophy that undergirds the discussions with that idea of individualism, collectivism?
Well, actually, what I'm seeing right now, I think, is an unfortunate blending. I think it would be good for us as a country to recapture, the constitutional first principles that Kevin just articulated.
Canadian constitutional.
That's it.
Yeah.
Which takes a look at the good of the whole and connects the individual exercise of a right with, in fact, the promotion of the good of the whole. And within that context, what Kevin was just saying is that in the Canadian, how do I want to put this, legal tradition, it recognizes for the good of the whole, religion as a good, and the individual's right to exercise his or her religious choices for the good of the whole. Religion is a good. Where I'm seeing the blending, though, is where the American separation, as Kevin was articulated, leads to this sense of the privatization of religion and of one's faith, and keep it out of the public square, right? And we feel that pressure here in Canada also. If religion is a good, and is recognized as a good not only for the individual but also for the collective, then the insights of religion also ought to be good for the collective to be heard, to be listened to be respected, brought into public discourse, rather than saying, no, we need to privatize religion, put it off in the corner, right? And that's where you can see some of that that separation, as I'm understanding it, as articulated by Kevin, on the American side of the border, kind of creeping over here. So how do we reclaim that tradition and say, if religion is a good, and we're grappling with fundamental issues as a country, and right now, one of the things that's dividing us as a country is the understanding of the very fundamental question of what it is to be a human being. How can we have those conversations without reference to the insights of religion that have pondered that very question for thousands of years? Right? And I'm not seeing that kind of invitation to enter into that public discourse happen very often. So those distinctions that Kevin has made, and the recalling that Kevin has made of our constitutional foundations, I think is critically important. And how do we bring that forward and build on it?
But isn't it good? You said an unfortunate blending of American and Canadian presuppositions.
Blending in the sense of this idea that religion has to be privatized.
Oh, okay, because I was going to say it's a bit of a false dichotomy to say the individual versus the collective.
In that,
right?
You're right. Oh, for sure.
Okay.
Sure, yeah.
Now, do you find that the church does end up making decisions in a fairly different way in relation to the government, really on a practical level, when you think about how your relationships with American bishops? Like, does it really end up impacting the church quite a bit?
Well, one of the things I've noticed,
difference?
and I do admire this of the American bishops, I have to say, is that in terms of their government relations, they're far more advanced than we are in terms of how they structure themselves. Right? Oh, okay. Every state has a lobbying dimension, that they have good connections, and they're very much on top of impending legislation. They're able to get out there with statements. We're not that developed structurally here in Canada.
Bigger too, by far.
Much bigger, and much more
a little bit bigger.
Much more well financed.
The elephant
too.
in the mouse, you said? Right. Yeah,
right.
That's it. But this point, a question to pose to both of you is, when we're talking about this right to freedom of religion, the right to freedom of conscience, and maybe there's a distinction in this case between the two, but and I'll ask you first, Archbishop, is this right man-made or is it God-given? Is it an inherent right to freedom of religion, or is it more something we've agreed upon as a democracy?
Well, I think it begins with the inherency of the right. I mean,
It is inherent.
It's not up to the state to define and to assign rights. When it comes to human dignity, when it comes to the existence of our conscience and how we live that out, that arises out of the very nature of our human nature. Right?
So you're saying anything that's authentically a human right is inherent?
I would say so.
Okay, yeah. So if it's not inherent, then it's not a right.
How that plays out in the legal discourse, I'm not so sure, but certainly from...
Yeah.
I wrote I wrote a comment on this, at least, in the Alberta Law Review back in 2013, drawing upon another great philosopher, Jacques Maritain.
Oh, yes.
Who I really like, by the way.
Oh, I really like him too.
Who says that all law has to begin with eternal law. And from eternal law, you develop natural law. And from natural law, you develop common law. And from common law, you develop practical law. And so where we're at in terms of talking about the statute that was passed by the legislature of the province of Alberta is the practical law piece. But
so it's really downstream.
Yeah, but everything has to start at eternal law. And everything has to begin with law as a truism. And then it evolves through the various levels of the application of that we need to function in our everyday lives with the rules and regulations and protocols through eternal law, natural law, common law, and practical law. And I love that distinction from Jacques Maritain, and it's a distinction that I think is fundamentally true.
Is it still acknowledged, though, today? I mean, my question comes from the fact that we're living more and more in a society that doesn't recognize the existence of God. So that pure secularism from that point of view. And we're also coming to the point where we question even the existence of nature. Everything is coming down to the atomization of society, and it's just the individual is what exists, right? So how do you find that that's mitigating against those I think beautiful and important distinctions, necessary distinctions, right?
Our problem is, of course, day to day to day, we have to deal with the mundane. What am I going to make for supper? What am I going to wear to the office today? Am I going to drive my kids to hockey or ballet or whatever it is? And so we end up dealing with our world at the far end of the spectrum of law, and that is on a very practical basis.
Yep.
But what we have to do is we have to take the time to work backwards and to see the bigger picture, to see the broader genesis of what we do every single day. And we're so busy, we don't do it.
Yep.
And what we are really required to do is to take that step back and to breathe and say, yes, I have to make this mundane decision today. But how is that a part of the truism of our lives, of our humanism, of our spiritual and emotional and mental and physical selves, all wrapped up in a whole person?
What's a truism?
There has to be some things that are eminently true.
Just self-evident?
Just self-evidently true.
Okay.
And everything else ends up, as you move further down that spectrum, shading that until you end up with practical law arguments about whether the comma was in the right place when the legislature passed that particular section. But there has to be backing up and backing up and backing up and backing up something fundamentally right. Unquestionably true.
Otherwise, a court system really doesn't end up working at all.
Correct.
There's no fundamental truth.
Correct.
You serve with 11 other judges, correct? Is that
that was the number. I think we've had a few very recent appointments, but I think we're at 13 now.
Okay, so
on the Court of Appeal of Alberta.
Okay, on the Court of Appeal.
And that's full-time.
Yes, those are the full-time justices. Have you found that, again, with that Canadian pluralism, and I would assume, which is also a philosophical pluralism about what is eternal law, I'm assuming you and your colleagues don't always have a completely unified view of eternal law versus natural law versus common law. I guess that's the point of having more than one judge, because there is diversity of view. Do you find that causes... Obviously, it does cause... We all know we follow court cases and there's division.
Absolutely.
Yeah.
I would say that we very rarely agree on most things, fundamentally. Because, we all have different experiences and we have different belief systems and we have different political philosophies and different views of the law. There are the living tree interpreters, and then there are the originalist interpreters. I mean, we come from very, very different places. And the joy of being at an appellate level court is you always sit with 3 or 5 judges, depending on what the issue is. And that means that to come to a conclusion, you must get these very, very different people coming from very, very different places to come together to give you a decision, or perhaps a decision for the majority and a dissent, or perhaps a concurrence, which is halfway between the two of them. But I think what I always say is it's a team sport, and you've got to know that there are a lot of other people on the field or on the ice with you, and you play as a team, and you're an individual, but at the end of the day, it's a team sport.
You mentioned earlier in the conversation that you didn't see there being many challenges on a court level to constitutional issues. Have you found in the aftermath of COVID that there has been some cases specific to do with religious freedom? Because we're certainly seeing that in the news in Canada, where there's been different cases that have gone to trial, or maybe they've been settled. But either way, people have sued, as I understand it, regarding religious freedom and freedom of conscience, regarding whether it was vaccine mandates or closure of churches or just a variety of issues that have come out of the pandemic. So when you say that there hasn't been challenges to the Constitution, how does that relate to some of those cases?
Well, it's a wonderful question, because this morning I was thinking about that very thing, and I walked into the library and there were 2 other judges sitting there, and I said, have we ever dealt with a constitutional challenge under Section 2A of the Charter arising out of COVID?
Yeah.
And the 3 of us sat there, looked at each other and said, no, we haven't.
Really?
And then we said, why not? And the answer, I think, is very technical. Yeah. And it's very technical because there have been those kinds of claims made. But they've been resolved on a very technical basis, not on a constitutional basis so far. So, for example, the most recent example was striking down all of the vaccine vaccine requirements and COVID prohibitions because they were made by the wrong political party.
Oh, I remember that, yeah.
Body. They were made by the cabinet and not by the chief medical officer. And therefore, and that was because, of course, a political conflict that was happening there, and therefore all of those charges were stayed by the Crown prosecutors.
And you're talking about this specifically in Alberta.
In Alberta, yeah.
Yes, in Alberta.
And so the reason we haven't seen them is because they've been dealt with on technical bases and not fundamental constitutional rights bases.
Well, that's interesting, because you'd get the impression when you're reading the news, I think that I think that people claim them to be constitutional issues, but you're saying that they're not being resolved on the constitutional level, even if the claim or the agitation is about a constitutional issue?
Correct. And that's one of the old truisms about law, and that is, if you can answer a question on a non-constitutional basis, you are required to. So if there is an administrative law basis or a practical basis or a statutory interpretation basis, which is more specific to this question, and is a smaller, tighter issue, you're always required to answer it on that basis, rather than venture into the big, huge world of constitutional rights and fundamental freedoms. And the reason why is because you have a danger of answering the big question incompletely if you don't have all of the facts necessarily before you to do that. And you don't ever want to do that. So you want to answer the questions in the narrowest, tightest possible way. And it's only when you can't do that that you end up having the fundamental questions, like, for example, the greenhouse gas reference or the Bill C-69 industrial assessment reference, because then you end up having to answer the big question. But normally speaking,
you resolve it before you get there.
You resolve it before you get there. Absolutely.
So in your case, working with the Court of Appeals in Alberta, if hypothetically, if someone sues on the basis of the right to freedom of religion or freedom of conscience, and I mean, the COVID cases are a good example. Someone says, our church should have been able to stay open, or we shouldn't have had to wear masks, something like that. How does, in simple terms, I know this may not be a simple answer, but in simple terms, how does one decide whether that's going to be resolved on the provincial level or whether it's going to be taken to the Supreme Court and become more of a national issue?
Right. Everything starts off at a provincial level.
Yes.
Quite often they start off with a criminal charge that might be dealt with by what used to be called the Provincial Court and is now called the Court of Justice of Alberta. And then it might go to the Court of King's Bench, and then it might come to us on an appeal basis. But the big leap is between the Court of Appeal in the province, which is the top level court in the province, and the Supreme Court of Canada. Because the Supreme Court of Canada is a court of policy, and they will only hear a matter of national importance that requires that they make a policy decision about the law, a policy decision about politics in the law, or the philosophy of the law, or the big questions. And that's why they only deal with 50 or 60 decisions in a year, whereas the lower courts are dealing with thousands and thousands, and we're dealing with hundreds and hundreds.
Do you find that people, especially when regarding religion or conscience, do you find that people try to sue in a way that would get them to the Supreme Court? Like they're trying to get out of a provincial resolution and they want it to be national?
There are bodies of people that really would like a question to be framed so that eventually it could be answered by the Supreme Court of Canada. Right. There are people who want the big answers to the big questions. Do they get there very often? No, they don't. And it's because, when you've got a judge on a Supreme Court of Canada that's going to be writing really important policy decisions, they only want to tackle 50 a year because they want to get them right, and they want to debate them for 18 months, and they want to have huge arguments and battles in the back room about it, and they want to have 15 and 20 and 30 and 40 interveners telling them what they think they should do. They want to do it right, so they can only do it for a very, very few number of cases to do it right.
Do you have any other thoughts on this?
Well, I'm kind of wondering, now I know we have to be, you're a justice, right, of the courts, and there's limits to what you can say publicly. I understand all of that. So if this question is inappropriate, I know you'll tell me, but I'm thinking of the fact that you and your colleagues at a Court of Appeal level you're high, right? You're high up. And the higher you are, the more you can see the whole terrain.
Correct. And
the more you can see what's coming. And I'm kind of wondering, certainly within the context of freedom of religion, freedom of conscience, do you and your colleagues ever, you're dealing with what's put before you, obviously, but is there a space where you talk about, we can see that this is going to be coming at us probably down the road. So when it comes to this area of freedom, religion, conscience, challenges to it, what are you seeing that maybe we need to be alert to, prepared for, that kind of a thing? Is that a fair question?
Sure. No, that's a perfectly fair question. I told you about my trip to the library this morning to chat with two of the other justices. Yeah. And both of them said, and I completely agreed with it, oh, I hope one of these comes to us because I really want to deal with it, and I really want to get into the questions, and I really want to fight about...
Basically constitutional nerds.
Constitutional nerds. That's right. All three of us were saying the same thing. Please let one come. Let one come. We desperately want to be able to write on this.
We'll work on it, right?
But you're right. We only deal with what comes to us. And can I predict what's going to come to us in the area? That's an impossibility. I just can't. I can't make that prediction. But I got to tell you that we're all very excited if one is going to come to us, because everybody on our court would love to wade into it and hopefully sit with 5 judges so that you've got 4 other people to be fighting with, working with, writing with, to come to some of these conclusions.
Now, I know that in different circles there's certainly concern and sometimes allegations that because of and this is a certain perspective, there's definitely a perception that Canada's government, and I think you've articulated this partly, is in some sense more inherently secular than the American form of government. Now, that's a big presupposition, but coming from that, I've certainly seen people raise concerns about the fact that Christians in particular in Canada are receiving some sort of persecution, is a term I've heard used, but maybe in less extreme words. There's a perception that the courts or the government in general just doesn't favor Christian principles. Now, I know that can be a tricky question to answer, but do you see that as a trend in Canadian law, or do you really have faith that there is really genuine pluralism when it comes to bias?
Now, let me tell you, I don't think the courts can favor a law that favors any particular religion. So it can't favor Christianity over Judaism. It can't favor Christianity over Islam. It can't favor Christianity over Buddhism, whatever. But I think that it's, from a legal point of view, it's well understood that we have to have a law system that respects all religion and that attempts to foster all religion in a neutral kind of a way, and also to foster non-religion, people who are, adamant secularists, for example, atheists, they've got to be allowed to be included in the pluralistic view of the world. And there have been 2 really good recent Supreme Court of Canada decisions that say that. Trinity Western University said that. And what was the other one coming out of Quebec?
Loyola.
Loyola, thank you. And Loyola, thank you. That's great. You want to join my legal team?
You got the job. You've been poached.
And they went to a great length to say, regardless of what a particular government may say or do, and I'm thinking, for example, about Quebec and secularism laws, and you can't wear public symbols if you're in the public service. Regardless of what they may do, the law itself has got to remember that we respect religion, we respect all religions, we want to foster all religions, and foster those people who are secularists, and we want to be pluralistic and open and communicative in that way.
Now, pluralism, I've certainly seen it viewed as a sort of vice, especially from a religious standpoint. I mean, in religious circles, I sometimes hear that term used very negatively. It's kind of like the blight of Canadian culture, is the fact that we're either actually pluralistic or that we're trying to be pluralistic. Do you see that term as having several definitions? Or, depends who you are.
It depends who you are.
Yeah.
The Catholic Church is a big tent church. It goes from, small L liberal to small L conservative, persons, both theologically and philosophically. And I agree that there would be a segment in the church that would see the way the courts interpret pluralism as being too liberal. But then I know that there are lots of segments of the church that think that it's too conservative. And one of the things we always have to keep, I think, in mind from the legal point of view is not to get distracted by, the liberalism of it or the conservatism of it, but try to think about the law as a neutral party that recognizes the big tent that we all live in. And I think the Catholic Church particularly is a very big tent. It has people from every single perspective, I think. And I think one of our jobs is to hear from people from every single perspective. Frankly, I think that's what the Synod on Synodality was all about, to allow that to occur and to hear from the spectrum and to allow people to talk to each other no matter where they are on that spectrum.
It's certainly true.
Well, I wish we could learn to do that as a country. So there tends to be a thought that, Canada is a secular state. And well, there's a secularization that does happen, but fundamentally we are a pluralistic state in the sense that we've been talking about. And the church, recognizing that is constantly, it has been for decades, calling us to engage that pluralism through authentic, respectful, mutually respectful dialogue, where we really come to know and understand one another, learn how best to live together, et cetera, et cetera. Challenge right now is that we're not doing it. We've lost the ability, it seems to me, to have dialogue, to listen to one another. We've devolved into a very divisive shouting past one another or at one another. And so how can we, just generally speaking, acknowledge the pluralistic reality that's here, enter into respectful dialogue, and maybe learn from the law's own overarching respect for religion per se and for the individual instantiations of it.
I've certainly seen when I observe American political culture and just how the law is approached in America, that it does seem more religious, especially because of the stronghold that evangelicalism has in the States, especially within the Republican Party. And whereas Canadian parties, I just find are just far more secular, at least how they present. That's my perception. But I find that because of that, you also have this, again, I would say maybe a misrepresentation of Canada's actual history, because I'm thinking particularly of, I think it's called the Lord's Day Act.
Right.
Yeah, maybe you could talk a little bit about that, because when I was reading about this particular piece of legislation, it just made me think, Canada, first of all, is a baby country. We're only like 150 year plus old. We're so young. So is it even true when we look back at our fairly recent history to say that it's always a secular state? Because, again, do you want to elaborate on what that act is, the Lord's Day Act?
Sure. In fact, I can tell you a lot about it because the case that decided that the Lord's Day Act was unconstitutional is called Big M Drug Mart. And I worked on that case on behalf of London Drugs.
Wow.
Yeah, so I've got a pretty deep understanding of...
I did not know you worked on that case. That's
wow.
Yeah. Great.
I was very young because it's an old case. The Lord's Day Act was established primarily to recognize a day of worship, and that day selected was Sunday. It was evolving over the years to a day of rest, but it was still Sunday. And it was fundamentally put into place to respect Christianity and respect the religious day to be Sunday, as opposed to Saturday for Jewish persons, Fridays for others, Thursdays for a group that I don't remember right now. And the issue in Big M Drug Mart really was, is it fair to turn a statute that was specifically drafted to preserve a day of worship at a specific day which is associated with one religion compared to others.
Yes.
Particularly since a person who was Jewish, for example, couldn't work on Saturday for Jewish reasons, couldn't work on Sunday for secular reasons, and therefore were restricted to working 5 days a week instead of 6 days a week.
Oh, wow.
Or whatever it happens to be. Or if you were Islamic, or if you were Seventh-day Adventist, or if you were Mormon, or somebody who would work on a different schedule. And the answer was, it's fine to say that there should be a day of rest, but you cannot say that it is a specific day that was designated to be a day of worship for one of the religions.
Right.
And so they struck it down as being unconstitutional. And it was not saved by Section 1 because the greatest good for the greatest number of people were to allow them to worship on the day that they wanted to worship and work on the day that they wanted to work.
And the Lord's Day Act, it was struck down in what, like 1984 or mid 80s or?
Sure.
Something. Okay. But when did it come into effect?
Oh, the early 30s.
The early 30s. Okay. So I guess at the time it probably would have been more relevant because Canada, there was an assumption that way more people were Christian. So it wasn't immediately struck down because it was just, sure, we can do this.
Absolutely.
Okay.
Absolutely. It was the social evolution of the demographics of our country that caused people to be concerned about. I'm taking the Jewish example. Yeah. The woman who worked at the Hudson's Bay store. This was an actual example in the case. Who said, "I need to work on Sunday because I can't work on Friday after about 4 o'clock. I can't work at all on Saturday. I'm a single mom with 2 kids, and you've got to let me work on Sunday."
Where did this was this national? A national law?
No, it was an Alberta law.
It was an Alberta law.
Lord's Day Act, yeah.
So when you think about how the relationship between demographics, the evolution of demographics, as you were just saying, and how that affects law and our interpretation of something like the right to religious freedom, do you? Maybe I'm putting this in. Well, I'll go with it. Do you see that as a positive thing? That, for instance, if Canada became vastly secular, if just by the way the church's relationship with broad Canadian society changes, if a vast majority of Canadians were to say we don't profess any religion and we certainly don't profess Catholicism, is that a good thing that the law and the government is just basically reflecting whatever the demographic morphs into? Because that happens with any country, right? As culture changes, should the government and the law have a little bit more of a grounding to tradition and how the country was founded, or is it generally positive that we see the courts and we see government reflect the actual community?
I would hope that the government and the courts would reflect more than just social demographics.
Right.
And I expect that is the case. If you to go back to what you had drawn on from Maritain about those 4 distinctions of the law, there are some certain fundamental truths written into nature and into human nature that don't change, right? That must honestly and always be acknowledged and respected, even as the social demographics might shift and swirl around them. Whether that's always the case in the thought of legislatures or the thought of jurists, I don't know. I think it needs to be, though, and hold all of these in balance.
Because I've heard it described by perhaps an American perspective that Canada is more of a truly pure democracy where it's like tends towards what the majority says goes, as opposed to America, which is more authentically constitutional, which is, well, our Constitution says this even if a vast majority of people are not on board with the Constitution. And of course, that's being highly debated in the West, just in general. But do you think that's an overly simplistic view of Canada being really a pure democracy, where it's like if 60% says, then we go with that?
There is a distinction that exists both in the United States and Canada, but is different in the 2 countries in terms of how it's interpreted, and that is between an originalist interpretation of Constitution and a living tree interpretation of Constitution.
Right.
And the predominant view in the States, I think, and I may be overstating this, is that you look at the Constitution and you say, in 1776, what did this mean? And it's got to mean exactly the same thing, and it's never changing, and it's never evolving, and it must stick to the original intention of the drafter.
Right.
Okay, and that's called originalism. And I think the predominant view in the States. The predominant view in Canada is the living tree concept of constitutional interpretation, and that is the Constitution must be read in context, and it is the definition.
Present context?
Well, it's the definition of what the context is.
Oh.
That's really the critical thing. Lady Hale of the British House of Lords once famously said, context is everything in law. And that is, we're required to look at the context and then interpret the words of the Constitution given the context. So the biggest issue on some of those big references, for example, that I spoke about, is what is the proper context for it? And I think that the proper context is the broadest possible context. Right from the pen of the drafter through the evolution of the country, through the present day position, through Maritain for levels of law.
Which is is it eternal, natural, common, and practical?
You're very good.
Okay, yay! I get a point.
You're very good. That's right. And I think the broader the view is, the more correct the answer is going to be on a Canadian basis, and that is the greatest good for the greatest number of people in the interpretation.
But it does. The Canadian, your perspective then is that the Constitution definite interpretations do evolve and they should evolve.
Yes.
Okay.
All I'm saying is that is the predominant Canadian view.
Matthew, I think our producer Matthew has a question too.
Yes, I had one question, Kevin. You're sitting right in front of a picture of St. Thomas More, a Man for All Seasons movie poster.
Maybe he's off
yes, behind me.
And famously a lawyer.
Yep.
What do you do as a Catholic justice, Catholic judge, a Catholic lawyer, when you there is a contradiction between the common law and divine law?
The prayer of St. Thomas More is...
Here, we'll pull you closer.
The prayer, you're right, I'm looking to the left now.
Yeah, we did.
The prayer of St. Thomas More has always been a bit of a guide to me in terms of answering that question in terms of balance. And I've got to tell you that the Red Mass is coming up next week from the date of this particular taping. And my topic for 20 minutes is going to be on that topic, and that is the balance of faith and law. But I finished that off with the prayer of St. Thomas More as a foundation to that. And here's what it says. And I think that all lawyers and judges should pray this on a daily basis because it answers your question, and that is, pray that for the greater glory of God and in pursuit of his justice, I may be able in argument, accurate in analysis, strict in study, correct in conclusion, candid with clients, honest with adversaries, faithful in all details to the faith. Sit with me at my desk and listen with me to my clients' tales. Read with me in my library and stand beside me in court, so that today I shall not, to win a point, lose my soul.
Ooh. Wow. I don't know what else you've got on your
We got
plate,
nothing.
but
I think he just closed it.
That's what I was going to say. I mean, that's an extraordinary, beautiful, potent prayer on which we can end. And by the way, you made mention of the Red Mass next week, at which you, sir, are being honored.
Yes.
To say so. Heartfelt congratulations. Well deserved.
Yes, well deserved.
I'm not sure well deserved.
Well, then let me assure you.
All right.
Yes.
All I know is that they wanted me to speak for 20 minutes. Other than that, I have no idea what's happening.
And the Red Mass is hosted by?
The St. Thomas More Lawyers Guild of Northern Alberta.
Okay, yes.
And it goes all the way back to the 13th century.
Wow.
and we adopted it in the Archdiocese of Edmonton in 1963, and have celebrated the Red Mass as the opening of the Fall Assizes of the Court almost every year. I think there was a couple of years where things didn't happen, but almost every year since 1963 in the tradition of the English courts of the 13th century.
Wow. Well, we'll definitely have information in the show notes about the Red Mass, the history, because that's such a beautiful tradition that we have continuing in our archdiocese. And thank you for coming on. It's been really wonderful. I've learned so much. And your grace, thank you as always.
Oh, no, glad to be part of this. And if I may, Kevin and I have been friends now for quite some time.
Absolutely.
And it's a wonderful, wonderful opportunity now to be able to gather and sit down like this and have this kind of a conversation. Thanks, Kevin.
Couldn't agree more.
My pleasure.
So thanks, everybody, for watching. Hope you found it helpful along your journey of faith. Please know that I'm praying for you. And if you would, be so kind as to pray for us also. Every blessing to you. God bless.